Hello, Assalamu alaikum. How are you all? So every time I have the intention to talk about the legal matters. As a part of this is my holy day. So in this session, I would like to talk about the legal matters, which is much more important in our social practice, legal practice, and the legal circumstances. I feel like that I have to talk with this matter. I have to talk over this matter. So in today's discussion, the topic is that British colonialism and the British colonial effect of our legal mentality. First of all, I have to mention what do you mean by the British colonialism. British colonialism mean actually a crisis whether people usually follow the British instructions, British rules, British figures, British documents, British precedent, even the British behavior in their personal lifestyle, in their professional lifestyle, or in their collective lifestyle. So it is actually rational and important to identify the British colonialism because before 200 years ago there was a situation people usually follow the British mandate, British curriculum, and the British activities. But right now, this is the time of 2026. We have to more update, we have to more supervised about the issues related to the British colonialism effect. So scholars have different types of opinion about the British colonialism. Some of the scholars believe that British colonial effect has a very good identity to supervise everything, to make a very good mandate for accessing the justice in our common practice. On the other hand, some of the scholars they believe that British colonial effect has lots of colonial ideology and slavery system, and people are gradually turned into the British colonial effect by following the British strategy and the British colonial effect. So I have to mention what is the importance of British colonial strategy and British colonial document also. So in the previous time we have lots of rules, regulations, and document which has been directly made by the British regime. For example, we have Penal Code 1860, we have Code of Civil Procedure 1908, we have Criminal Procedure Code 1898, even we have Evidence Act 1872, we have a Specific Relief Act 1877. So these types of laws are directly or indirectly reshaped and reinterpreted by the British colonial legal strategy and the effect. Even people are getting lots of success and ideological practice on the basis of these documents, on the basis of these laws and regulations. So you may ask that what is the importance of the British colonial effect? Yes, the biggest important is that they had made lots of laws, and these laws are actually important, rational, effective, and profound, as well as it is irrelevant for our legal system. The second reason is that British regime has had interpreted everything for our system, for our legal system, for our administrative system, even for our executive system. The third reason is that a state is actually based on the three things: judiciary, executive, and the administration. And these types of issues and clever definitely identified by the British religion, British regime. So you can't say that British regime has no effect in mentioning our judicial effect and the judicial citations. Definitely it has the biggest issue for the development procedure of our common sense and common practice. The third reason why British colonialism and British legal effect has a great view for developing our judiciary and our administration system. You know that we have a Police Act, the Police Act 1860 on, and this law has been interpreted by the British colonial effect. Until now, this is the time of 2026. Right now, we are following the Bengal regulations of police, even the Police Act 1860 on, for the development of our society's structure and the society's practice. So how you can evaluate that British colonial effect has no identity, British colonial effect has no interpretation over the issues of our legal and the social justification. In that perspective, I can say that I'm not an astrologer, I'm also an advocate. So I have seen from the very beginning of my graduation and the professional system, every criteria, even the every stakeholders are totally depend on the British philosophy. For example, whenever we are teaching and reading the jurisprudence or penal code or evidence acts, this is definitely led by the English philosophy and the English lexicographical resource. Even you are not able to achieve these types of expertise in this field, whenever you are not able to get the sequence of English fluency in your sentence structure and in your sentence analysis. From this perspective, I have to say that British colonial effect has a great contribution on our British legal education. The fifth important why British colonial system is literally important for the development of our legal system, because British colonial system is structured, and before 250 years ago there was no situation, no document, no legal analysis or no legal interpretation which will definitely help to identify and make structure our legal system. So from this perspective, I have to admit that British colonial mentality is far better than our ideological practice. So you know that every space has some advantage and the disadvantage also. So first of all, I have to mention the advantage of the British colonial mentality right now in the practice of 2026. The first important and first advantage of the British colonial system is that British colonial system has lots of good effect, and we are also enjoying these types of good effect despite lots of social, cultural, political and ideological view in our legal system. So from this perspective, definitely I have to admit that British colonial system is far better than any kind of legal system in the universe. The second reason is that British colonial system is totally depend on the precedent based system. Even you know that whenever a judge is giving his judgment, he is using his judicial mind, judicial conscience, or more even he is using the textbook, law books, or different types of judgment. So one of the basic characteristics of British colonial mentality is that the judge will follow the precedent. So I have to clarify what do you mean by the precedent. Precedent means the previous judgment. So in the British regime and British regime's analysis, precedent has a very good view overviewing our legal system in the future time also. So in the previous time, precedent had a very good effect interpreting our legal system. Right now we are also emphasizing, right now we are also creating a very good vibe by interpreting the precedent for a very good promote justice from the court. In the future time, whenever our future judge, whenever they have intention to interpret the rules on the basis of the golden rules, lexicographical resource, or on the basis of the textual method, definitely the judge will follow the precedent, because precedent has a very big impact for interpreting our legal system and the legal analysis. So this is one kind of basic advantage of the British system. The third reason is that after 300 years later, because this system had been organized in the year 1661 with the help of the East India Company, for the first time they had established the British colonial philosophy and legal mentality with the help of Regulating Act 1873. And right now this is the time of 2026, but this time their effective situation, their ideology, their philosophy, their structural method is literally important for the present day's analysis of the British legal system and British legal analysis. The third reason is that what is the importance of the British colonial mentality in the present affection. For example, we can say about the shaman. Shaman means to identify the another person during the time of the court proceedings. This is the one kind of principle which has been also mentioned in the natural justice principle. So in the natural justice principle, there are three dimensions. One is no one cannot be judged for his own case. The second reason is that odi alteram partem, and the third reason is that speaking orders. So even whenever we would like to clarify the concept of the odi alteram partem, so odi alteram partem resulted in the shaman. Even shaman is the direct result of the odi alteram partem, which is more focusing on the basement of the natural justice. So whenever the judge will give the judgment without following the natural justice, without following the rule of law, without following the proper emancipation, there can be no good verdict, there can be no very good judgment. For making a very good judgment or judgmental view right now, we have to follow the British instructions. So from this perspective, we have to follow the British colonial mentality and ideology. So even I have already mentioned there are some effective issues and there are some effective issues also. So in this mechanism I have to also mention the disadvantage of the British colonial mentality and the practice. The British mentality is totally a sophisticated culture, but we are the Bengali people, we have the individual identity, we have the ethnic minority, even we have the indigenous culture and practice also. But most of the time we have not followed these types of issues for the ego based practice culture of the British colonial legal systems. For example, today this is the temperature is 35 to 45 degrees Celsius, but during this time of the court interpretation, we are wearing a coat, we are wearing a blazer without any kind of justification. So Bangladesh right now processing of the summer day. So we have to wear the flexible dress. We have to wear the comfortable dress, but we are not following these types of practice because of our ego, selfishness, and the British colonial mentality. So as far as it possible, Bangladeshi government have to take the effective responsibility in removing the legal culture and the legal practice for the ends of justice. Before ensuring the justice, we have to ensure the mentality, very good mentality on the basis of our indigenous culture, indigenous purview, and indigenous social practice. Whenever we have failed to practice the indigenous culture, indigenous procedure, and indigenous proceedings, in that future time, our whole system will be diminished. Our whole system will be lamented. So I'm the advocate of just court. So in that practice I have also seen lots of difficulties, lots of dysfunction, even lots of disadvantage also following the British rules, culture, and practice. For example, sometimes the judge will not provide the verdict with a very short time, without any kind of reason, without any kind of justification. The judge are taking the time, uh, and the judges are making any kind of trouble in the judgment. So this is one kind of British colonial mentality. So even the British colonial effect has lots of problems also. One of the basic problem is that British colonial system is based on the discriminatory factor. So whenever we have a plan to justify the justice, whenever we have a plan to make a justice over the matter of justification, in that time we have to remove the British colonial effect from our legal context and the legal analysis, and we will ensure the justice whenever we will follow the absolute rules, practice principles of natural justice, rule of law, access to justice, and equity. And while I'm talking about the British colonial legal effect, we have to also talk about the British colonial advantage also. In the previous discussion, I have discussed everything about the British colonial effect and practice. Having lots of cultural and sociological practice of the British colonialism, definitely I have to say that British colonialism effect is the best effect to reintroduce, renovate, and reschedule the practice of the legal system in Bangladesh. Assalamu alaikum.